This is a very interesting development. I think it's important for me to read the portion of the motion that I think is most appropriate here. And this is what it says. In and around September of 2023, Mr. Bradley was visiting Mrs. Yeager in her office. Now, she was a deputy assistant TA or chief assistant in Cobb County, the neighboring office. So Mr. Bradley was visiting Miss Yeager there in her office when Bradley received a phone call. Miss Yeager could hear that the caller was the district attorney, Fani Willis. District Attorney Willis was calling Mr. Bradley in response to an article that was published about how much money Mr. Wade and his law partners had been paid in this case. Miss Yeager heard the District Attorney Willis tell Mr. Bradley, they are coming after us. This is a quote, you don't need to talk to them about anything about us. Now, listen, she had the right to hire outside lawyers. Then it says Miss Yeager watched Mr. Bradley's testimony before the court and became concerned as a result of the fact that Mr. Bradley testified to on the witness stand was directly contrary to what Mr. Bradley had told Miss Yeager in person. So this takes it to a whole different level because now you're dealing with what is basically you got to be realistic here. This is beyond jury tampering or witness tampering because the witness hadn't been sworn in yet. She hadn't been sworn in yet, as you said, Eddie. But this goes to the heart of obstruction of justice.
This is obstruction of justice, and if alleged and true as alleged, because it's an allegation that this is what the testimony would be, this is a serious infraction of the law by no less than the district attorney for Fulton County. When she finds out that they're worried about how much Wade was being paid in the case, she tells Bradley, they're coming after us, so you don't need to talk to them about anything about us. What are you talking about? You're supposed to be the district attorney, and you say disclose everything to everybody about all the true developments and what happened. You don't tell them shut up and don't say anything about us unless you've got something to hide or you're concerned about. But what bothers me more than anything, this is coming from a district attorney who is an officer of the court and who is making these statements to a third party.
Harry, what's your read on it?
Fani Willis was engaged in a conflict of interest relationship with Mr. Wade, and she benefited personally from it, and she attempted to hide evidence, clear and unmistakable evidence of this relationship, this financial relationship, from the court. So I think what we have here is either witness tampering, witness influencing, or obstruction of justice.
More interesting, Harry, to clarify that point. Andy makes a good point. It could have turned into witness tampering if Yeager had been sworn in. She hadn't been yet. So it right now goes to obstruction of justice.
I think that is correct. So what Fani Willis was anticipating was that Bradley would indeed be a future witness. So the tampering, if you will, hadn't yet occurred because he was not yet a witness. So she was basically saying, keep your mouth shut, don't tell the truth, and later in testimony before the court, before Judge McAfee, he did indeed indicate that he had sent a text message to one of the defense attorneys saying that there absolutely was a relationship.
Yeah.
And so to the extent that that text is accurate, it now suggests his claim that he was merely speculating was indeed untrue.
I want to put that part of it aside here because this is new evidence. You're right that that's been the historic evidence that's already been submitted before the court.
Right.
So that's before the court. There's no need to open up the court proceedings for that. What's unique about this is, and there's testimony going right now on in the Georgia legislature where Ms. Merchant, the defense lawyer, is talking about the situation with Fani Willis. But what is relevant right now is that the phone call was received and the DA was focusing on the payments that were being made.
Correct.
And that is what the DA tells Bradley, they're coming after us. You don't need to talk to them about anything about us.
That's very disturbing if true. And I think
by the way, she had the right to pay him. I mean, so we're not questioning that.
I'm not saying that she didn't have the right to pay a contract employee. Judge McAfee said if he's got a bar card and breathing, you can hire him. I'm not going to look at his his entitlement, his qualifications. But the concern that I have is that you've got an article that appears. It talks about the money that was being paid, And DA Fani Willis tells Mr. Bradley, they're coming after us. You don't need to talk. Of course you need to talk to them about what's going on. You're the district attorney. You shouldn't be telling a witness not to do what justice requires to be done in the case. If that in fact turned out to be the case, then something needs to be done about it.
So the motion that's pending is to open up, basically, it's a proffer, open up the evidence again. He'll probably let the other side, let Fani Willis respond, which he needs to.
Sure.
And then set another hearing. So this evidence portion's not closed. Like I said, the ACLJ, I want to find out what I can about all these agreements and side agreements and whatever these things were. I think we need to know that. Let's go to Jerry in Rhode Island on line 1. Hi, Jerry. Welcome to broadcast. You're on the air.
Hello, team. Good discussion. Yeager, in her capacity, hearing this statement inadvertently, hearsay statement, but once she sees the testimony, she then becomes aware that there's fraud on the court. Is it her incumbent upon her under professional responsibility to bring this forward in case she gets attacked?
Let's break this down. This is not hearsay.
No, it's not, because Fani Willis is the respondent in the motion. She is present in court and can be cross-examined, and therefore there's an exception to the hearsay rule, and it's an admission of a respondent, and it's admissible. Against interest, and it's admissible.
Yeah, so it's admissible. It's not hearsay. That's number one. Number two, with regard to Yeager's responsibility, well, I don't know what took this. Remember, the case only closed out less than a week ago.
Right.
So in this intervening days, I think it was Friday of last week, right? Okay, so today's Tuesday. So this happened immediately. She sees the testimony. You don't know what negotiations were going on between her office and defense lawyers and her Cobb County office. You can't just run into court when you're a lawyer, as Fani Willis did. Most lawyers can't do that, Harry.
I think that is correct. I would argue that Ms. Yeager had a responsibility to inform the court that she possessed evidence contrary to the claims made by a witness or a series of witnesses with respect to a public hearing. So Ms. Yeager had no affirmative obligation to contact Judge McAfee until the evidence was adduced in front of the court. And once which was just Friday, and once that evidence was adduced, then I think it would be professional malpractice on the part of the attorneys for the defendants in the election interference case not to attempt to reopen the hearing and reopen the evidence.
That's an important thing what Harry just said. So you put yourself in the lawyer's standpoint, the lawyer that had the information. They need to then go to one of the defense lawyers and say, I possess evidence that is contrary to this. So then the defense lawyers would have to basically question her, find out what that is, and then put it into motion. So I don't think, Jerry, there's a gap of time. It was Friday. She probably contacted them over the weekend. They drafted the motion up and filed it yesterday.
Yeager did what she was supposed to do. She heard testimony that she believed to be untruthful. She went to the defense counsel. She told them about it. They investigated it, and they made their motion. That's what happened in the case. And now it's up to Judge McAfee to decide whether he's going to hear the evidence or not.